Make sure you're sitting comfortably because Keir Starmer's been accused of misleading the public. Again. Only this time by the IFS, the Institute for Fiscal Studies. They've called him out on his comments on the defence spending. So this is a bit of a weird one, but hopefully I will simplify it in this video. And later on in the video, what do you think about trans women police officers searching women without their approval, their consent, and being able to use reasonable force if they refuse? More about that in the second half of the video. Please do stick around for that. But first of all, this is a bit of a weird one. Let's go to this article in the Telegraph here. I'll link it below. Now, the IFS says that Keir Starmer has essentially misled the public because he said that they are increasing the defence budget spend from 2.3% to 2.5% of GDP, and said that it was £13 billion. But the IFS said that's somewhat misleading. They say that raising the budget from 2.3 to 2.5 involves a comparable increase of less than half of that amount. They say, and by the way, that's only by 2027. Now, aside from the fact that they had to rush VAT on school fees through straight away in the middle of an academic year at the start of January, this won't kick in until 2027. So just a comparison there. But to make this increase, Keir Starmer said that he will reduce the overseas aid budget from 0.5% to 0.3%, thus a shift around of the money. But Ben Zaranko from the IFS doesn't agree with that analysis. He says that the £13.4 billion increase effectively assumes the defence spending will be frozen in cash terms over the next 2 years. Paul Johnson accused Keir Starmer of, quote, playing silly games with numbers. But looking further at what Mr Zaranko said, he said the Prime Minister, Keir Starmer, followed in the steps of the last government by announcing a misleadingly large figure for the extra defence spending that this announcement entails. An extra 0.2% of GDP is around £6 billion. And this is the size of the cut to the aid budget. Yet he trumpeted a £13 billion increase in defence spending and says the figure only seems to make sense if one thinks the defence budget would otherwise have been frozen in cash terms. This is, of course, dwarfed by the significance of today's announcement, but is frustrating nonetheless. Now, I've seen all sorts of commentary floating around on this on X. Many people supporting it, many people saying that they don't support funding war and instead that we should be funding things at home. Now, again, there are lots of different views on this. I'm not going to tell you one view is right or wrong. Everybody has a view. But what I do think is wrong is if these numbers are not quite correct, they are somewhat massaged and somewhat misleading. Because I personally, let me know in the comments what you think. I personally think that every word out of every politician's mouth should be absolutely the concrete truth. Now, we've heard lots of things over the last couple of years. We've heard lots of claims, we've heard lots of promises, and we've seen lots of promises being broken. But this seems to me to be a casual use of figures and numbers to try to make an outlandish claim that sounds very impressive when he says that he's going to spend an extra £13.4 billion defending Britain, and then only for it to be labelled misleading by Britain's leading and actual economists. But now moving to equally frustrating headlines, this from the Daily Mail. Fury as trans police officers will be allowed to strip search women. And of course, many people have asked where the law lies on this, and many bits of it are up in the air. But more about that in a moment and what I really think. Don't go away. Now, as a quick aside, many of you know I've had my fair share of problems with mobile phone providers, but I'm pleased to say most of those are now sorted out, but particularly my travel needs when I need to stay connected to the internet when I'm traveling. Because you might remember my son went abroad and my then mobile phone provider just couldn't connect him, which was really frustrating and somewhat stressful. But since then, I've partnered up with Saily, which provides seamless internet access via an eSIM, which you install on your phone. It's really easy to do. You download the app, you buy a plan for the country of your destination, and it activates when you arrive, giving you affordable and seamless internet access when you arrive. No bit of plastic arriving in the post, no confusing plans or roaming charges or confusion as to what you'll be billed and when and how. but it will all be within that package that you buy from Saley. Of course, you don't have to buy it straight away. Just download the app today and it'll be ready for whenever you need it. But with Saley, you get seamless internet connection in hundreds of countries. But not only that, because Saley's brought to you by NordVPN, you also get lots of security features. Of course, you get a virtual location like NordVPN, so you can change your location virtually, avoiding lots of problems you might have with certain apps, but also an ad blocker to avoid all these annoying ads, but also, most importantly, web protection to detect malware on websites or software while you're traveling, especially important when you're connecting to strange networks and Wi-Fi connections in places you just might not trust. And of course, as a partner to my channel, I get you a fantastic discount, which is 15% off any plan you choose to buy using the code BlackBeltBarrister, which is on screen right now. But of course, you don't have to buy it straight away. Just download the app today, so the next time you're traveling and you're wondering whether you'll get internet connection on arrival, you'll have the app with you, buy a plan, use the code BlackBeltBarrister for 15% discount, and it will just activate seamlessly when you arrive. No more worrying about whether you connect to the internet when you arrive, because that is just the most frustrating thing. Checking your emails, everything else, worrying about Wi-Fi networks. Just download Saley today and that will take care of it for you. And thank you to Saley for sponsoring this video. So the Mail reports that it's seen new guidance documents, despite the National Police Chiefs Council withdrawing the policy last year that would allow biological males identifying as female to conduct, wait for it, more thorough intimate parts searches of women. They withdrew that guidance last year, but the Mail says that it's seen new guidance and says that forces will be advised that trans officers can now still strip search people of their newly acquired gender if they have the relevant documentation. And of course, they refer to a gender recognition certificate issued in accordance with the Gender Recognition Act of 2004. Mayor Forstater of Sex Matters says paying £5 for a piece of paper from the government doesn't turn a male police officer into a female one, any more than wearing a dress or putting on lipstick. And of course, I have to say at that point that people that hold those views and express those views are entitled to do so. Mayor Forstater's case itself held that gender-critical beliefs are a protected belief under the Equality Act, and you have the right to express those beliefs within reason, which I'll explain here. The summary of this case, if you're not familiar with it, Maya Forstater, the claimant in this case, holds gender-critical beliefs, which includes the belief that sex is immutable and not to be conflated with gender identity. She engaged in debates on social media about gender identity issues, and in doing so made some remarks which some transgender people found offensive and transphobic. Ultimately, the first tribunal ruled against her, but that was appealed, and the appeal tribunal ruled in her favour, that it is a protected belief under the Equality Act, and you do have the right to express those beliefs, within reason, which I'll explain. Paragraph 103, the tribunal said the second error here, the first being that it's not a protected belief, the second error imposing a requirement on the claimant, Maya Forstater, to refer to a trans woman as a woman to avoid harassment. That was an error, the tribunal said, to force her to do that. In the absence of any reference of specific circumstances in which harassment might arise, this is in effect a blanket restriction on the claimant's right to the freedom of expression insofar as they relate to her beliefs. In English, that means you can express your beliefs, and only up to the point that it might then become harassment, then you give consideration to harassment, but saying that you can't express those beliefs at all would be a blanket restriction and thus unfair. However, that right, the tribunal goes on, applies to the expression of views that might offend, shock, and disturb. So for clarity, expressing those views is a right of yours if you hold these beliefs to offend, shock, and disturb. It is not an offence to say something offensive, it is not an offence to say something that will shock somebody, and it's not an offence to say something that will disturb somebody. That is different to the allegations of harassment that one might get, which again would have a different context. The tribunal goes on, the extent to which the state can impose restrictions on the exercise of that right is determined by the factors set out in Article 10, sub 2. Restrictions that are prescribed by law, necessary in a democratic society, protection of the reputation of the rights of others, etc. It seems that the tribunal, the original tribunal's justification for this blanket restriction was that the claimant, Maya Forstater's belief, necessarily harms the rights of others. As discussed, that is not correct. Thus, again, for clarity, it was not correct for the tribunal to rule a blanket ban on expressing these beliefs because they harm the rights of others. The tribunal now goes on and clarifies the harassment point. Whilst the claimant's belief and her expression of them by refusing to refer to a trans person by the preferred pronoun or by refusing to accept that a person is of the acquired gender could amount to unlawful harassment in some circumstances, it would not always have that effect. In our judgment, it is not open to the tribunal to impose, in effect, a blanket restriction on a person not to express those views irrespective of those circumstances. And the tribunal, in the bit in pink, bold, red, whatever, does clarify here, and I emphasize as I'm reading this out, that does not mean that in the absence of such a restriction that the claimant or anybody could go about indiscriminately misgendering a trans person with impunity. In other words, you cannot just do whatever you like and say whatever you like without exception, because it might ultimately amount to harassment. The tribunal was making that point there. Why am I bringing this to your attention here? Because I think this is a very important case which will impact on any challenge to the police doing such searches. Now, as I go back to one of these articles again, it's reported in the Telegraph. I'll try to remember to link these in the description below. The Telegraph reports here that the police have revived these plans to allow transgender officers to strip search women. Now, given the fact that this tribunal ruled that gender critical beliefs, which just means that you don't accept and you don't believe that a trans person is the gender of the acquired gender, if that makes sense, that if you don't believe that that is possible, that is a gender critical belief, and that is a belief protected as a protected right under the Equality Act. You have the right to believe that, you have the right to express those views, and within reason up to the point that it might become harassment, which, as in any case, you're free to do and say what you wish, but of course there might be consequences, depending on what you say and to whom you say it, how often, and etc. All of those things can come into play. But given that this is a philosophically protected belief, how then would it be possibly justified for a trans police officer to search a woman that holds those beliefs and fundamentally does not believe that a trans woman police officer is a woman as the acquired gender when it comes to a more thorough intimate parts search? They refer to it as strip search, which sounds bad enough, but the full term for it is a more thorough intimate parts search. So it includes stripping, but it includes everything that you can imagine that to mean. And I think that is fundamentally wrong. And I think that because this is indeed a philosophical belief which is protected in law, any such search like this would be absolutely open to challenge. And I, for one, whilst this is obviously not legal advice nor making rulings on the thing, but I, for one, think a court should uphold that claim. If a woman was searched by a trans woman police officer against her will, against her wishes, against her philosophically protected beliefs, I think that is fundamentally wrong, and I think that challenge would succeed in court. And interestingly enough, the Equality and Human Rights Commission recently intervened in a case involving NHS Fife with the doctor and the nurse. You must have seen that on social media about providing single-sex changing spaces and things like that. Baroness Kishore Faulkner, chairwoman of the EHRC, said as follows: "As Britain's equality regulator, we promote and enforce compliance with the Equality Act. Health bodies in Scotland, England and Wales must have an accurate understanding of the operation of the Equality Act as it relates to the provision of single-sex services and spaces. Today," she said, "we reminded NHS Fife of their obligations to protect individuals from discrimination and harassment on the basis of protected characteristics, including sex, religion or belief and gender reassignment. Under the public sector equality duty, all Scottish health boards must assess how their policies and practices affect people with protected characteristics. We've requested that NHS Fife provide us a copy of the Equality Impact Assessment relating to the provision of changing facilities for staff, any information relevant to how such policies have been kept under review, etc. We've highlighted that the Workplace Health Safety Welfare Regulations 1992 state that changing facilities will not be suitable unless they include separate facilities for or separate use of facilities by men and women where necessary for reasons of propriety. The Health and Safety Executive approved code of guidance, etc. This week, media reported on NHS Scotland's forthcoming Guide to Transitioning, which the Scottish Government confirmed has been shared with health boards in preparation for this implementation. It's important that this guide and all guidance, policies and practices which rely on it faithfully reflect and comply with the Equality Act 2010. We've asked to meet with the Cabinet Secretary to discuss this Scottish Government's role in ensuring that NHS Scotland and other bodies meet with their legal obligations of the Equality Act. In other words, they need to meet certain requirements for providing single-sex spaces for men and women where necessary for reasons of propriety, which would include, in my view, honouring the protected philosophical beliefs such as gender-critical beliefs in cases such as this. So this effectively was the regulator stepping in to say, we remind you of your obligations, the Act protects individuals from discrimination and harassment on the basis of protected characteristics, and reminding them that changing facilities are not suitable unless they include separate facilities for men and women where necessary for purposes of propriety. And this whole situation is coined and summarized very well by this article in the Express. Again, I'll link below to give you a range of articles to read here. Women are being forced into court to stop men using their changing rooms at work because regulators have failed to enforce the law. The HSE was told that it was well past time for it to issue clear guidance to employers about single-sex spaces. Maya Forstater, commenting on the case, said it's scandalous that women such as Sandy Peggy and Eleanor Francis have had to put everything on the line because regulators have failed to uphold laws that have been in place for decades. Not only have these legal challenges come at great personal cost, but fighting them has been an inexcusable waste of scarce public funds. It is well past time for the HSE to act. It is responsible by statute for enforcing the 1992 regulations, which I mentioned earlier, that are meant to guarantee safe workspaces. She goes on, it needs to make crystal clear to all employers and public bodies that they are legally bound to provide separate sex washing, changing and toilet facilities. And I can't really believe that I'm having to go through bits of law like this and explain how this works, but the law is on their side. But at least so long as the Supreme Court, from whom we're waiting a judgment, comes back with a judgment that upholds all of these principles, which says women, biological women, are protected and their philosophical beliefs are protected in the same way that these current laws are supposed to reflect. Let me know what you think in the comments about any of that, and if you want updates on these sort of things, which many media outlets probably won't talk about in as blunt a fashion as me, but I'm entitled to do so, please do subscribe to the channel. I depend on you to do that, and I'm very grateful for that. But in the meantime, thank you for watching.